The doctrine of Taqlid is usually explained in terms of following the opinion of a qualified jurist. The final requirement of the doctrine, however, is to follow the approved law of the school. The doctrine stated in its actual form is as follows. It is wajib or obligatory to follow the approved law of the school. We have elaborated this doctrine at length in a previous video. The next question is whether we have to follow a single school or more than one school, according to our choice. The answer to this question is given in different ways depending upon the school. Before we answer this question, we need to understand that the question applies to two situations. The first situation pertains to the traditional Islamic law developed by the schools through their interpretation of the legal content of the Quran and the Sunnah. Modern scholars do not speak the language of the jurists. That is, they are mostly out of touch with the work of the earlier jurists. Being out of touch with their work means that they cannot undertake ijtihad or interpretation like the earlier jurists who developed the law over the centuries, especially during the first 5 centuries. Indeed, the work of the earlier jurists has been so thorough and exhaustive that one is forced to ask the obvious question, have the earlier jurists left any part of the text uninterpreted? Have they left something for modern scholars to work on for the solution of modern problems? This question is extremely important and needs to be answered in some detail. The companions, God be pleased with them, began interpreting the legal texts of the Quran and the Sunnah. They were followed by their students, who became leading jurists in different regions. These jurists interpreted and reinterpreted every legal text for the derivation of legal rules. They identified the underlying causes, ilal, wherever possible. It can safely be said that not a single legal text was left that was not investigated and discussed threadbare by these jurists. It is to be noted that there are very few texts in the Quran and the Sunnah that convey single agreed-upon meaning. In other words, most of the legal texts are subject to interpretation or ijtihad. It was this ijtihad that was exercised by the Muslim jurists. The result was that all kinds of opinions that could possibly be derived from these texts were derived and analyzed. The work of the jurists was followed by the writers of tafsirs, who may or may not have been jurists. These writers developed the discipline of tafsir into an independent field, just like the experts on traditions developed their own field into a recognized science. During this entire process, all the texts were interpreted and reinterpreted with different opinions being given for the identified meanings. Among these texts were the legal texts that the jurists had already worked on. Thus, the work of these interpreters supplemented the work of the jurists. Any kind of meaning or interpretation that may have escaped the scrutiny of the jurists was taken up by these interpreters. In short, the interpretation of the legal texts of the Quran and the Sunnah was finalized by these experts in the first 5 or 6 centuries of the Hijrah. This, however, was not all. We have shown in our book called Defending the Frontiers of the Hanafi School that the jurists developed their legal knowledge into 9 recognized fields. After all this development over the centuries, is there any scope for the modern scholar to add to the legal rules already derived from these texts by further interpreting the texts of the Quran and the Sunnah? It is possible, but will be rare. The result is that modern scholars have nothing to add to the corpus of law already developed by the jurists. All that they can do is quote several jurists and then choose one opinion arbitrarily as the best opinion. This is exactly what we find them doing. In fact, in the book mentioned, we have stated that it is very difficult to alter the Hanafi law that was fully developed more than a dozen centuries ago. Besides other reasons stated in that book, one of the reasons was that they had refined the interpretation of the legal texts to their limits. Does this mean that modern scholars have no role to play in the development of the law? Is the situation that depressing? The reason is that the earlier jurists have interpreted the legal texts of the Quran and the Sunnah to the limits. That is, the derived legal meanings and the underlying causes stand recorded in the manuals of the jurists. What sources will modern scholars then use to solve new problems? The area of new issues and problems is the second situation to which the following of a single school applies. Is the answer going to be the same as it will be for the first situation of traditional law in which the texts of the Quran and the Sunnah were relied upon? In other words, will a single school have to be followed for the rules dealing with new cases not dealt with by the earlier jurists, and that will now be derived by modern jurists or scholars? We will first try to understand the meaning of a school of law and show why one school is essentially different from another school. The obligation to follow a school has already been shown under the explanation of the Doctrine of Taqlid. Here, we will show why it is essential to follow a single school of law. Finally, it will be shown whether it is necessary to follow a school of law or a single school for the second situation of modern problems and their legal solutions. We have stated again and again that the schools of Islamic law are not sects. They are scientific systems that have been developed to manage and operate the legal system that arises from the texts of the Quran and the Sunnah. To borrow an analogy from the computer world, they are like the different operating systems, Windows, Macintosh, Unix, Linux, AIX, Herd, Apollo OS, and so on, that control and run the computers for achieving the various required tasks. One can move between these systems, but to function properly, one has to move completely to one system. The schools of Islamic law operate in more or less the same way. Let us explain further. To understand the meaning of a school as well as the difference between schools, we shall lay out the broad principles of the Hanafi school and then compare each principle for its acceptance in the Shafi'i school. This can be done for the Maliki and Hanbali schools as well, if one likes. The principles, only a few examples, may be stated in the form of a list. The Quran is a source of Islamic law. Yes, but the general word in the Quran is definitive, and only another definitive evidence can restrict it. Thus, a khabar wahid being probable cannot do so. According to the Shafi'is, the general word is probable, and the khabar wahid can restrict it. According to the Hanafis, the Sunnah can abrogate the Quran, and the Quran can abrogate the Sunnah. The Sunnah can abrogate the Sunnah, and the Quran can abrogate the Quran. According to the Shafi'is, the Quran can abrogate the Quran and not the Sunnah, while the Sunnah can abrogate the Sunnah, but not the Quran. What is proved through a definitive evidence in the Quran with respect to acts of worship is to be treated as fard or definitive obligation as compared to the wajib or obligation. According to the Shafi'is, there is no difference. They are all wajib or obligatory. The Sunnah is a source of Islamic law. Yes, but traditions are of three types: mutawatir, mashhur, and wahid. According to the Hanafis, according to the Shafi'is, there are only two, mutawatir and wahid. The traditions with complete chains are accepted, but so are the mursal traditions by the Hanafis. In fact, the mursal traditions may sometimes be stronger than the masanid. According to the Shafi'is, the mursal is not acceptable. There are major differences between the two schools with respect to literal construction of the texts of the Quran and the Sunnah and the proving of the rules through such interpretation. The opinion of a companion, especially a jurist companion, is binding, according to the Hanafis. According to the Shafi'is, the opinion of a companion is not binding. It may or may not be followed. Qiyas, analogy, cannot be used for extending the scope of crimes. According to the Shafis, it may be used. Qiyas al-Shabah is not to be used, as it is not proper analogy. According to the Shafi'is, it may be accepted. Istihsan is a legally valid source of Islamic law. According to the Shafi'is, istihsan is batil, a nullity. The qawaid fiqhiyya function as binding pieces of evidence and are an essential part of both deduction and induction used in the derivation of laws. According to the Shafi'is, the qawaid fiqhiyya do not function as pieces of evidence. They are merely guides. The maqasid al-sharia are the ultimate, though remote, qawaid fiqhiyya. They operate within the domain of siyasa sharia for the derivation of the laws not directly covered by the texts of the Quran and the Sunnah. According to the Shafi'is, as qawaid fiqhiyya are not pieces of evidence, the objectives are merely guides. Ikhala may be used instead. These are only some of the principles of interpretation or ijtihad within the Hanafi school. There are numerous other principles, and we have barely scratched the surface here. The large body of such principles taken together is what constitutes the Hanafi school. The same is to be said about the Shafi, Maliki, and Hanbali schools. The differences between the principles of the schools, even though they unanimously accept the first four sources, shows that each school has a unique set of principles, and each school has its own independent character. Further, the differences can lead to differences of opinion when applied by different schools. The principles within a school are not only different from those of the other schools, but they are also internally consistent within the school. If some of the principles of one school are exported to the principles of another school, there will be a clash, and the principles of that school will collapse with a domino effect. When a scholar or a jurist follows one school today for issuing a fatwa where the opinion is based on the principle of istihsan, but tomorrow he follows another school which rejects the principle of istihsan, then he has mixed up his principles and committed an error. The reason is that he is saying in the same breath that istihsan is valid and istihsan is a nullity, which is a blatant contradiction. Yes, if he moves over completely to the other school and for all opinions, then his action will be sound. For then he has given up istihsan and all the other principles of the school that he leaves behind. The same is the case with every other principle. General word is definitive. No, it is probable. Mursal is acceptable. No, it is not acceptable. Opinion of a companion is binding. No, it is not binding. And so on, all in the same breath. The conclusion we may draw from all this is that every modern jurist, mufti or scholar must follow a single school if his opinion is to have any value. If he wishes to move to another school, then he must do so completely and base his opinions on that school. For the layman, there is no problem. According to some jurists, he may move to another school if he likes and then come back to his old school and continue to move between schools, even if he is following his whims. We find it difficult to subscribe to this idea. What is wrong for the jurist is wrong for the layman. If he moves to another school, he must move completely for all opinions. We will return to this issue in what follows. In the present times, we find highly respected scholars, professors, and legal experts undertaking what is called takhyir. For example, a scholar will mention several opinions and then say, "This is the one I choose." Most university professors do it today, especially in the Arab world. The learned Abu Zahra does it in his books, as do many other well-known writers. If all these learned scholars are performing pick and choose, there must be some reason for it, a possible legal basis. The first thing to notice is that these scholars are undertaking this practice by completely ignoring the body of principles of interpretation that we have mentioned in the previous section, which is the meaning of a school. They are simply focusing on the derived opinion, that is, on the output of ijtihad. From one perspective, this is blind taqlid, or the very essence of taqlid, that is, following an opinion without questioning the principles or sources through which the opinion has been derived. Up to this point, the person adopting some opinion is on firm ground, but when he says, "This is the one I choose," he appears to be acting like a mujtahid. The reason is that we have a right to ask him for his basis for choosing one out of several opinions. Does he base this choice on some skill in the principles of interpretation? Is he choosing the opinion just because he likes it or it suits him? We believe it is the latter. This is the situation we have described in the last paragraph of the previous section of the layman pursuing opinions, even if they are based on his whims or hawa. We may, thus, conclude that pick and choose is the case of a scholar or mufti, moving across school boundaries in search of a desired opinion, in absolute disregard of the principles of interpretation of all schools, and adopting the opinion when he finds one that suits him. What then is the legal justification for this practice? The basis for this practice appears to be in the well-known issue: is each mujtahid right, or is only one of them right? There are many details in the issue, but we will simplify it and say that the majority of the jurists maintain that each mujtahid is right, while the Hanafis maintain that there is one right answer and all others have made an error that is without sin. Al-Ghazali gives detailed arguments, but we may say that the majority believe that opinions are like the colors in the universe. For example, so whichever color a mujtahid chooses is acceptable to Allah. In practical terms, it will mean that whichever opinion a scholar or jurist chooses is acceptable to Allah. This means that it will not matter whether the person choosing an opinion today is a layman, scholar, professor, author, or someone else. They will all be right. This is exactly what the doctrine of pick and choose stands for. The Hanafis maintain that there is only one right answer. They rely, among other arguments, on the tradition that says there are two rewards for one who gets the right answer and one reward for one who makes an error. Besides the rewards, the tradition indicates that each mujtahid is not right, and there is only one correct answer. Moving from one school might, therefore, mean that one is moving away from the right answer to a wrong one, while there can be no guarantee that one is moving to the school that has the right answer. The Hanafis, thus, claim that they have the right answers, at least most of the time. Therefore, the follower should stay with the school and not move to another. We have stated above that the earlier jurists, writers of tafsirs and other professionals, have interpreted and reinterpreted all those texts that could possibly have legal content. Not only have they interpreted the texts and extended the legal meanings as far as is literally possible, but they have derived all underlying causes ilal, on the basis of which the scope of the texts have been further expanded. The jurists, having realized that they had given finishing touches to the task assigned to them, came up with a new methodology that was to apply to the derivation of rules for areas that had not already been covered by the jurists. This new methodology was not to apply to the laws that had already been derived by the jurists, but was to cover all those situations that would be faced by the Muslims in the future, that is, the unoccupied or unaddressed area. The Hanafis clearly stated that the new methodology was to be addressed by the siyasat or policies, both social and judicial, that have been called the objectives of the Sharia. The objectives, as the ultimate principles, were to guide the creation of new principles and rules through what has been called maslaha mursala. New laws are being derived today in the case of rituals, zakat, Islamic banking, criminal law, and family matters. We really do not know what methodology is being used by those who are deriving these laws, irrespective of their being scholars, institutions, or even states. We have suggested elsewhere that whoever issues a fatwa must give detailed reasoning through which he has arrived at his opinion. Fatwas issued without reasoning, or one-liners as we called them, are no longer reliable. In this new world of haphazard fatwas, no one is asking the most important question: is it necessary to follow a single school for these fatwas? The result is that fiqh has become a free-for-all activity that is being invaded by mostly unqualified people who have no methodology, nor are they even aware of the fact that some methodology is required. If this situation continues, Muslims will soon lose their legal identity and will be at the mercy of alien powers for their problems, as in fact they already are. It is, therefore, time to ask, which school are we following?